Good afternoon. My name is Ruby Powers. I'm board certified immigration attorney with Powers Law Group, and this is our weekly Facebook Live. We're going to cover all the major topics of what's happened this week in immigration news, including what's going on with public charge issues, updates with DACA, some recent news about a forgery by an ICE agent, and also updates on a case that restricts the amount of continuances given to people in immigration court, as well as an update on family separation and ACLU case with Miss L, and also Pareja, the Supreme Court case that came out in June, and just what that means. We'll be doing one very likely later on today on Pareja more specifically, and we will have the Spanish version of what I'm talking about soon after we finish in English. So let's go ahead and get started. All right, so much news every week. Hope you're having a good week. You know, the summer's almost over. Lots of kids have already started going back to school, and Houston Independent School District starts in a couple of weeks. So one more week actually before school starts. All right, so the first article we wanted to mention was this. The ACLU states the citizenship USCIS has conspired with ICE to trap immigrants at visa interviews. So this has happened to at least 17 people in 2018, and what it is that people were going to immigration interviews when they had a removal order and then they were detained. Now this we know of this happening even in Houston area. So the bottom line, it's unfortunate that people who are trying to find a way to have a path to legal immigration are being penalized in the root of this. But the big takeaway is that if you are filing and you don't have an experienced immigration attorney, please get an experienced immigration attorney, because it is very likely that if, for example, a person had a former removal order and they are applying for an I-130 based on marriage to a U.S. citizen, for example, they're at the interview, they're going to the interview, and ICE could pick them up, the immigrant up, because of the former removal order. So this is happening. There was always a fear this could happen, but we know firsthand this is already happening, and it's happening around the country. So the second point we wanted to talk about was public charge and what we know so far. So public charge has always been an issue and a form of inadmissibility. It basically means that you have to prove that whoever sponsors you will make sure that you will not be a public charge, which means you will need government benefits of some sort. There's always a definition of it, but it's being broadened, and the Department of State came out with a broadened definition recently, last year, and the USCIS, or Department of Homeland Security, hasn't come out with it yet, but they're already starting to use what they haven't implemented. They haven't brought out and given further clarification yet. In interviews, they're asking more detailed in USCIS interviews, but we also have a lot of people are asking us, I have prima facie VAWA, and it says use this to go apply for benefits, but then now you're saying maybe I won't be eligible for a green card if I use my benefits. So the bottom line is, if you are using any type of government benefits, if you can potentially stop using them, but if it doesn't put your family and life and health at risk. But the same thing is, we don't know what this policy is going to look like, and very likely it could be challenged in litigation. So someone recently said that I was forced to get ACA, and then I'm being told I might be penalized for having gotten the ACA with the insurance. So I think that there's going to be, every time the policy comes out, there's always some problem with it in some respect, or there's some question that wasn't clarified, and there's some other way of looking at it. And so that's always what's going to happen that's why there's policy, FAQ, frequently asked questions. There's going to be litigation. But we're watching it. The thing is that if this is a concern of yours, keep watching being on our newsletters in English, Spanish, and watch our Facebook Live. As soon as we get more information, we'll keep sharing it, as well as all our social media like Twitter, Facebook, LinkedIn, Instagram, and all those things. So the third point, and so basically that's it about the public charge. And they're saying it comes from Stephen Miller's plan to represent a biggest change to legal immigration in decades, and it can affect 20 million immigrants. I mean, and that's basically what we're seeing here is this issue of challenging legal immigration. And under the plan, they would broaden public charge. Anyone who's used subsidies available under the Affordable Care Act, some forms of Medicaid, earned income tax credit, food stamps, or the Children's Health Insurance Program could potentially be under scrutiny. And it's not in law yet, but the State Department's Foreign Affairs Manual is already instructing consular officers on this, and so we've already been preparing our clients who are doing consular processing. You know, an op-ed came out last week or this week, I don't know, and it said, you know, well, then an immigrant could be potentially challenged between deciding whether to get health care for their young child or whether they're going to have a path to naturalization. And I mean, this is a hard predicament that I don't think immigrants should have to be put in that position to choose between the health and the safety of their child versus their legal future and stability and status inside this country. On to DACA, our third point for the day. Basically, you could still renew. We're still waiting to see if we get a new filing, but renewals are happening. You can renew early, and we're seeing renewals in about a month, approximately. And we need to just still be advocates for the DREAM Act. You know, it's an election year, and we need to keep fighting for that because. We've kept it going, right? I mean, remember almost a whole year ago when DACA was completely killed, basically, by the president, and then with litigation, it kept being revived. So now people are still able to renew it. So we need to see the power of that, speaking up, registering to vote, voting for those who are eligible, and advocating for those who are qualified. There's another case that came out about a forgery. It's really big in today's news about the forgery by an ICE agent. And basically what happened is that an immigrant was deported because apparently they had signed something that said they wanted voluntary departure back in the past. And it was only figured out by an immigration attorney had done a Freedom of Information Act request and had found out there were inconsistency between the document that they had been provided and the one that was in the file from the government. And it came to find out that a person in the government had forged a signature just to force the person to be deported. It wasn't until experienced immigration reviewed the case that they noticed a document stating that the person, their client, had apparently signed a voluntary departure, but really it was forged. So we're going to find out more about that. But the bottom line is that have an experienced immigration attorney. And also do Freedom of Information Act requests. In general, they are really great resources because there could be something in the past. I'm getting a lot of consultations right now where people might not have any other form of relief, and I'm asking some very probing questions like, how did your parents get green cards or legal permanent resident? How did other family get it? And, you know, trying to find out if there's some other way, like 245I, Western Hemisphere, registry. Like, there's some old case law that can still be helpful. And it's really important to have someone who's experienced to help you. One of our thing that happened yesterday, Attorney General Jeff Sessions issued an order through a case. It's called I think it's called Matter of LABR. And basically the bottom line is that immigrations can grant motions for continuances in removal cases only for good cause shown. And it limits the discretion, what good cause standard limits the discretion of immigration judges and prohibits them from granting continuances for any reason or no reason at all. So they have to have a really good reason, basically. And, you know, this recent article, it says, you know, Sessions has been unusually active in his practice compared to his predecessors, exercising intervention authority to make it harder for some people to legally remain in the U.S. I mean, really, he has been. Matter of AB, and now this, that he's personally interjecting himself. The Attorney General said in decision yesterday, uses of continuances as as a dilatory tactic is particularly pernicious in the immigration context because people in the country illegally who want to remain have an incentive to delay their deportation as long as possible. Okay. There's a lot of reasons why people need continuances. They might be eligible for something else that takes the government a long time to adjudicate. It could be with USCIS and their court cases, and it has different jurisdiction with the EOIR. There's people who are eligible for U visas, but they take years. And people are now being sent home wherever they're from, even though they have a possible U visa. Before we would get continuances for those, but now they're being sent home. People have I-130s pending, and now this is becoming difficult to get continuances. Basically, get an experienced immigration attorney to help you because you might need to think of what you're going to do if the judge does not grant you a continuance. And we're down to the last couple points. Pareja. This was a case from June 21st from the Supreme Court. It's Pareja v. Sessions. And this could possibly affect your immigration relief in some cases. It was based on the notice to appear, which is the notice that sends you to court. And the Supreme Court said the notice was invalid if it does not include the date and time of your hearing, even if you sent a hearing notice at a later point of time. So the reason this is an issue for two reasons. One, for a person who would be eligible for cancellation of removal, but for the notice to appear might have stopped the clock. Seems a little technical. We'll get into it in another Facebook Live or video that's more specifically to Pareja. But bottom line, if you ever were given a notice to appear to go to court, and it said to be TBD, to be determined on the time and date, it's possible this Supreme Court case could help you in that you might be able to restart the clock for cancellation purposes. But in some jurisdictions around the country, it might even allow you to help terminate your court case. And so if you've been put in immigration proceedings and you were given a TBD, you might get a consultation. Just get one, because this is a recent change that happened, and there's been a lot going on this summer, but there's been a lot of different ways to interpret what's happened. But just get a consultation soon, because in some cases people are only going to have until September 19th to file any new relief under this because of the 90 days, which is only about a month from now. So look into that. Pareja v. Sessions, if you have a notice to appear that had a to be determined date and time, get a consultation. And the last point is what we've been talking a lot this summer, and this firm's been really focused on, was the dealing with the separated families. We have pro bono cases, low bono cases. We've got clients all over the country right now that we're helping, and we've helped get out of detention and reuniting them. The government has largely reached an agreement with immigrant rights advocates on a revised plan to reunite the hundreds of families separated. Thursday court filing, the DOJ, Department of Justice lawyers, said the changes would ensure an efficient process for reunifications. ACLU said in a separate filing that some families could be made whole only if parents were returned to the U.S. and the failure to address this was significant. So the plan is the second stage of government efforts to reunite. And we already, so as of Thursday, which was yesterday, 541 of the children remained separated. 541. And under the care of ORR, down from the 559 a week ago. So only a small handful were actually reunited in just the last week. Many of those who separated were crossed at the border illegally and were seeking asylum. We know that. So there's still 541 children separated from their parents, and many of them have been separated since early May. Somewhere between early May and the policy to quit separating was June 20th. So, wow. So it could be theory 3 months that some of these kids have been separated, 3.5 months. The reunification plan outlines means to locate removed parents, determine their intentions for their children, and it would require government to arrange travel for children being reunited with their parents in their countries of origin, and ensure the reunifications would not impair the children's future ability to seek asylum if they return to the United States. Department of Justice lawyers urged Sabro not to adopt a position to take by immigrant rights advocates. They said the advocates want to grant children removed by of removed parents a legal right to demand the return to consult on asylum. The government strongly disputes that this right exists and believe granting the result would directly and significantly interfere with reunifications. So there's 541 kids still separated for probably 2.5 to 3 months, and they're trying to work out the details of how to get them with their parents, or whether or not the parents want them to stay in the United States. One of the other major issues we have, and we're almost done, is that if the children, the parents want them to stay in the United States and be placed with a sponsor, everyone in the family in that household has to be fingerprinted and had a background check. And so that's another concern of many people who would otherwise want to be sponsors, are concerned about not wanting to be one. So we're pretty much done here. Give us a call at 713-589-2085 in Houston, and in New Jersey we have the 201-210-8240. We go all over the U.S. for asylum interviews, adjustment interviews, immigration court. So we have a team of lawyers, speak lots of different languages, we'll have a lot of experience. You can look us up at rubypowerslaw.com. We're here every week to give you information in English and Spanish, and our newsletter goes out every other week in English and Spanish. And if you have any questions throughout the week or during our post, you can post them on our Facebook Live. We hope you have a great and safe weekend, and thanks for watching.